Good afternoon, ladies and gentlemen. This is your host, Elgin Martinez from the Immigrant Edification TV, the only channel that addresses real immigrant issues, coming to you with another informative video. But before I go into this video, ladies and gentlemen, I need to expound on something. A lot of so-called believers, right? I'm going to get on some of your case right now. A lot of so-called people that go to church and say that they believe in God, claim to say that Mr. Trump wasn't put into office by God. Then if he's not put into office by God, then who puts him there? You understand? A lot of you need to have some faith, man. I mean, what's the purpose of you going to church if you don't have faith? You understand what I'm saying? For example, I just came from the gym, right? If I don't see any kind of transformation, then it's like pointless going to the gym. You understand what I'm saying? So that being said, ladies and gentlemen, you all need to understand that President Trump can only work within the parameters that's given to him by God. That's it. You understand? He cannot work outside of what God allows him to do. That being said, I'm going to go into the other video. This other video is going to be for anyone who wishes to adjust status in the US. There was a new form that was brought out. The name of the form is Form I-944, Declaration of Self-sufficiency. Form I-944, and this is from the USCIS.gov website. Form I-944, Declaration of Self-sufficiency, is used by an individual to demonstrate that he or she is not admissible based on the public charge ground. An alien is inadmissible under INA section 212A4 if he or she is more likely than not at any time in the future to receive one or more public benefit as defined in 8 CFR 212.21b for more than 12 months in the aggregate within any 36-month period, such that, for instance, receipt of 2 benefits in 1 month counts as 2 months. Who must file for Form I-944? You must file this form if you are filing for Form I-485, application to register permanent resident or adjust status, and you are subject to the public charge ground of inadmissibility. In general, each applicant who submits Form I-485 must submit his or her own Form I-944 if the applicant is subject to the public charge ground of inadmissibility. How is Form I-944 used? Form I-944 is used to determine whether you are inadmissible to the United States under INA section 212A4 because there is a likelihood that you will become a public charge at any time in the future. We evaluate whether you are inadmissible by weighing all the positive and negative factors related to your age, health, family status, assets, resources, and financial status, education and skills, prospective immigration status, and period of stay. We also consider a Form I-864 affidavit of support under Section 213A of the Act if you are required to submit Form I-864 as part of your adjustment of status application. That being said, ladies and gentlemen, who is exempt from filing Form I-944? If you're a victim of domestic violence or a self-petitioner, you are exempted from filing this form. A special immigrant juvenile, certain Afghan or Iraqi national, an asylee, a refugee, under the Cuban Adjustment Act, for battered spouse and children, based on dependent status under the Haitian Refugee Immigration Fairness Act, based on dependent status under the Haitian Refugee Immigrant Fairness Act for battered spouse and children, under the Indo-Chinese Parole Adjustment Act of 2000, as a Polish or Hungarian parolee, as a Nicaraguan and other Central American under Section 203 of the Nicaraguan Adjustment and Central American Relief Act. Ladies and gentlemen, sadly we've come to the end of this video. Please share, like, subscribe, and hit the notification bell. Last but not least, thanks to all my viewers for supporting this channel.